Some new information on a story we have covered extensively here on Happening Now. The now debunked and retracted Rolling Stone article about a gang rape at a fraternity house at the University of Virginia. Well, a judge just tossed out a defamation lawsuit brought by 3 former fraternity members against the magazine. Joining us now, Bob Bianchi, criminal defense attorney and former head county prosecutor and trial attorney, and Richard St. Paul, criminal defense attorney. The article was completely full of holes, completely made up as far as we can tell. 3 of the former members of that fraternity who have since graduated brought suit, actually right here in Manhattan, said they had been defamed by that article, but the judge says no. Why?
Judge is absolutely correct, John. Defamation is one of the hardest cases to win under the law because of the First Amendment implications. And it's not so much that the story was untrue. What this judge basically said was these 3 plaintiffs were not mentioned in the article. There was nothing that specifically causally related to any harm that was done to them. And they're just basically saying, because I was part of that fraternity, I feel offended. And lots of people go into court feeling offended, thinking that they're going to be legally protected, and they're not. The judge made the right call on this.
But still, Richard, I mean, the fraternity at the time was the subject of so much scrutiny, had its privileges taken away on campus. Everybody who was a member of that fraternity came under the microscope. Why should they not have some ability to recover?
Well, there's 2 issues here. First of all, we're talking about 3 individuals who were not identified, and the judge did properly dismiss the case because we don't know who these individuals were. There wasn't enough to connect these individuals. Now, you mentioned the second thing is you mentioned the fraternity. The fraternity was definitely mentioned in this article a lot and made the fraternity look bad, suffered irreparable harm likely, and in fact, the fraternity, which is Phi Psi, filed a separate action, or members of the Phi Psi fraternity filed a separate action on behalf of the fraternity itself, not the individuals. And that action is being heard in state court in Virginia. That's still an active litigation. I think it's very likely that they will be successful, the fraternity will be successful, because the fraternity was defamed in that article.
So if this article had been written and used actual names, or used, I don't know, would it have to use actual names, or would they have to use, could they get away with using descriptions of the 3 fraternity members?
That's a great question, John, because that's exactly what was argued. You don't have to use actual names, but here, for example, the perpetrator, actually the person who accused these people of this said somebody was riding a bicycle, and I feel defamed by that because I ride a bicycle, so people may think it's me. And somebody said that an incident happened on the 2nd floor, and the guy said, well, my bedroom is on the 2nd floor. That's not enough, but if you give enough descriptors where it's identifying a particular person without necessarily mentioning their name, and it is a defamation or slanderous comment, then they could have been held liable. And this judge basically said there was nothing that connected with anything in that article with these 3 individuals that sued. Therefore, they suffered no actual harm, and the case rightly needs to be dismissed.
Could the case be brought, or could a similar case be brought in another jurisdiction? I mentioned that they sued right here in Manhattan for a case that, you know, was about an event in Virginia.
And the reason why is because you have diversity jurisdiction. What that means is the plaintiffs live somewhere else, and Rolling Stone is actually headquartered in New York. So they have diverse areas in which they live, and so that allows you access to the federal court. But this res judicata, a Latin word for basically it's over. There is no more, you can't sue.
Well, they say they might consider an appeal, Bob.
Well, they can certainly appeal it, but I think that this judge is on solid ground. It has to be seen as an abuse of discretion. John, what you have to understand about this was this happened before the trial in a thing that they call summary judgment, which gives all the legitimate inferences to the plaintiffs in the case. And even with that strong law in favor of the plaintiffs, the judge rightly said there is nothing here in the facts that supports the law. I can't possibly see an appellate court reversing that.
But wait a minute, you know, the judge supposedly basically ruled that there's no damage to these plaintiffs. But, you know, if you're a member of the Phi Kappa Psi fraternity that particular year at UVA, and you told everybody on campus, you know, you go up to somebody and say, yeah, I'm a member of that frat, they'd say, oh, you know, you're the rapists or something.
Oh, yes, certainly, but that's not enough causation, or I'm sorry, casual connection between the individual and the article. That's just not enough. Yeah, They probably, because remember, they probably suffered, they probably were, not liked very much. But that's why I mentioned earlier, the fraternity suffered, the name of the fraternity suffered, and I think they have an actionable cause of action, not the individuals who are unnamed.
But that's an entity, that's not an individual.
Yeah, and I agree with that. And there's also a defense under New York law, which is what this is being analyzed under. The federal courts use the state law, which is called the opinion defense. And it's very relevant in this case because the statements that were made with respect to the fraternity weren't factual statements, they were opinions. And essentially the court's saying we don't want to penalize opinions of people.
And that's why the action was brought in Virginia instead of the federal court here in New York.
But one of the standards required to prove this is reckless regard for the truth, right? I mean, if you've got a completely made-up story, isn't that reckless regard for the truth?
Well, it's actually when there's a private individual and it involves a public institution, such in this particular case, there has to be a reckless disregard of the truth that is true, but it's based upon the factors and circumstances. And in my opinion, I never understood this. Rolling Stone had a person that they believed was credible who was giving information. And while they maybe journalistically should have done better checks and balances, it wasn't as if the author of the article felt that the information was wrong. So, based on all of that, I don't think it was a reckless disregard for truth. It may have been negligent. It may not have been journalistically integritable to do it. They could have done things better, but the law requires much more before you penalize free speech.
Yeah. Well, they say it was humiliation and emotional distress, but the judge says it was not defamation. Richard St. Paul, Bob Bianchi, thank you both.
Thank you.